Hello, everybody, and welcome to today's masterclass. It's the 8th one, so we are halfway now through our CPD masterclass series. Thank you to those of you who have joined us for all of the masterclasses to date. For those who are joining us for the first time, my name is Jessica Blumenthal, and I'm a director in the Banking and Finance Department at ENS Africa, based in the Cape Town office. We have, over the past 3 years, been offering this CPD series as a way to assist regulated persons, key individuals, and representatives in the financial services sector to gain the professional development hours that they require, and also as a way to further the conversation around ESG and sustainability in this industry. The ESG practice group at ENS Africa is made up of practitioners from different departments and different jurisdictions, working together to ensure that we're able to offer our clients holistic advice, which is cognizant of local and international developments in this emerging area. And you've met some of those practitioners during this series and will continue to do so for the rest of this month. Today, I'm very excited to be in conversation with my very good friend, Lizelle Bluchnoot, who is also one of our foremost competition law experts. And she is the representative in the ESG practice group, adding a competition perspective to our discussions and deliberations. Today, we're going to talk about South African competition law, the role it and our competition authorities have to play in preventing corporate outcomes which have a negative impact on our economy, people, or planet, and the enabling role which our legislation and competition authorities can play in incentivizing behavior that will further the sustainability agenda. So I'm going to give Lizelle an opportunity to introduce herself in a moment, but before I do that, just a few housekeeping points. Please remember that if you are attending today in order to achieve a CPD hour and get your certificate verifying that, please do stay online for the duration of the masterclass. We do verify attendance before we're able to issue the certificate, so please do bear that in mind. And then if you would like to ask any questions of Lizelle as we go, you can post them in the Q&A block at the bottom of your screen. And if we have time at the end of our discussion, we'll pose those to Lizelle. And if we don't have time, then Lizelle will be able to get back to you directly. Just remember, if you use the chat, we don't have your details and then we won't be able to get back to you. So please do remember to use the Q&A or the conversation block at the bottom of your screen. Then a reminder that we are, as I said, halfway through. So there are still 8 upcoming masterclasses for you to join if you need some more hours or if you find the topics of interest. So do get in touch with our events team if you'd like to register for any of those masterclasses. And then finally, just you should all by now have received an invitation to our cocktail meet and greet opportunities that we'll be holding at the end of this series at the end of the month. And the reason for that is that we wanted to create an opportunity for us to get together in person, considering that we've now had so many interactions over the screen, and for you to be able to meet some of the panelists and presenters who've made up the masterclass series. So we are holding an event in Cape Town and in Johannesburg. You should have received an invite to the one suited to your location. And we do, if you'd like to join us, please do. We'd love to meet you and have the opportunity to take this discussion further in person. So Lizelle, I think that's all I'm going to say by way of introduction. Can I ask you to join me on screen and to just give a brief introduction to yourself?
Thanks, Jess. I'm not sure if I'm on screen. I assume so. But thank you very much for the invitation to speak today. And thank you so much for the incredible work that you are doing to start and to keep this very important conversation going. It's people like you that change the world. So thank you so much for that. In respect to the attendees, welcome today. And I was swarming to see some familiar names. So welcome, everybody. So I'm, like Jess said, I'm Lizelle Bluchnoot. I am an executive in the Competition Law Department at ENS Africa. I'm an economist. Not a lawyer by training, and actually it's interesting for me, the ESG interaction with economics and the tools that economists use and that are used in the ESG arena, how compatible they are, and I'll dig into that a little bit further in a while. I've been with ENS for a wonderful 15 years. My practice is circles around merger control and not just in South Africa, in the rest of Africa as well. Then we investigate and assist clients who are investigated for anti-competitive practices, so complaint investigations, and a large part of our practice is circles around compliance with the various competition legislations across the African continent. So prior to joining ENS, I was the head of mergers at the South African Competition Commission, and obviously through my tenure there, got exposed to the regulators' view of the world, and I'm hoping to bring some of that into the conversation today as well.
Thanks, Lizanne. I think that does perfectly place you to be part of this conversation today. So the concept, Gazelle, of sustainability is not foreign to competition law and policy, I don't think. So where do competition law and sustainability intersect? Perhaps let's start there and then we can dig in a bit deeper.
Thanks, Jess. Yeah, I think you know, if you just start out with what is the purpose of competition law, if you see about, and this is globally, not just in South Africa, we've got a very special angle here in South Africa, but globally, competition policy is essentially about consumer welfare and achieving efficient outcomes, and not just achieving efficient outcomes for today. There is a forward-looking and a long-term look at what is efficient and what what serves, in other words, communities and economies. So I think from that perspective, there's actually a very strong common DNA thread between competition law and policy and the sustainability agenda. However, despite this, we see that there's actually very little happening on the competition law and ESG interaction, particularly in South Africa. I think the conversation in Europe and in the Americas is much more advanced than we have here. So when I talk about the interaction in South Africa, this is an academic interaction at this stage. It's not something that we see coming out of the competition authorities yet directly. But I think for the South African case, we just have to look at the objectives of the South African Competition Act to see how competition law and policy can align with sustainability objectives. And I'm going to, if you'll indulge me, just read out what the purposes of the Competition Act is, and I think you will recognize the sustainability background or backbone or the thread that you can pull through these purposes or these things. So, purpose of the Competition Act is to promote and maintain competition in order to promote efficiency, adaptability, and development of the economy. I don't think we have to struggle to find out what the sustainability angle is there. To provide consumers with competitive prices and product choices. Now there you can potentially see a short-term clash between sustainability and short-term gains, but still it's there. To promote employment, and employment is, ensuring more equitable participation in the economy, and not just a few that are able to participate in the economy, and to advance the social and economic welfare of South Africans. Then there's to expand opportunities for South African participation in world markets. Then I think another very important sustainability angle is to ensure that small and medium enterprises have an equitable opportunity to participate in the economy. And then very, very specific to our South African situation, to promote a greater spread of ownership, in particular to increase the ownership stakes of historically disadvantaged persons. So in my view, I think there's a lot of synergies between the underlying objectives of sustainability and the Competition Act in South Africa.
It sounds like it. And if we think of those policy objectives of the Competition Act that you've just shared with us, how does that then translate into tools that can support the sustainability agenda?
Oh, that's a great question. Thanks, Jess. There are basically two arms to competition law and the way that it is practiced, not just here, internationally as well. So the first set of rules is regard merger control, and that's basically to prevent anti-competitive structures from arising globally, we look at anti-competitive structures from arising, but in South Africa, we don't just look at the competitive impact of a merger. We also look at the public interest, but I'll talk about that in a bit. And the second is a set of rules that practices that firms may not engage in. So our merger control regime, like I mentioned, doesn't only look at the impact of the merger on competition. In other words, what would be the impact of the merger on future prices, future consumer choice, innovation, if we're looking at it in the longer run, and if it is an innovation market. So, because that's basically how we measure competitiveness, is by looking at prices and by looking at consumer choice, and then that translates into innovation as well. But then we also have the public interest test. In respect of the rules that apply to businesses, preventing anti-competitive conduct, there are also, again, two sets of rules. One set relates to unilateral conduct, so what may firms do and what may they not do. And then the second set is to collaboration amongst firms. For example, parties in a horizontal relationship or competitors, what kind of collaborative efforts may they not take on? And I think that's also where there's a strong touch point potentially with sustainability.
I'm going to take you back to the public interest consideration that you mentioned. So you've mentioned that when we're considering a merger, then there's a requirement for the competition authorities to consider the effect of the merger on the public interest. Can you unpack for us what is the public interest consideration? Because it seems to me that this is really where we can see this intersection best.
Yes, and I just before I jump into what these public interest considerations are, Jess, I think I must just bring back the point as well that this is unique to South Africa. We've seen other countries roll this out as well, this public interest test in their merger control, but South Africa was 25 years ago at the forefront of this development, and lots of pushback from international parties saying, but you are tainting the pureness of competition policy and law by bringing in these public interest tests, by bringing in something outside of the pure economic test that is a competition law. But what we are seeing more and more in the international arena is a call for similar provisions in other developed countries as well. The US is saying, well, maybe we should stop just looking at what we call the welfare standard, which is what's the impact of the merger on consumers of the products that are relevant to the markets affected by the merger. We must also look at other public interest considerations. Now, in South Africa, what are the public interest considerations that we look at? The test is basically whether a merger can or cannot be justified on public interest grounds, considering the effect that the merger, so merger specificity, not just, you can't just take it out of the air, merger specificity, the effect that the merger will have on a particular industrial sector or region. Now, it doesn't say what effect or what factors or what aspects of the industrial sector or region needs to be affected. So we can, that's quite an open-ended factor to take into consideration. And I think there's an opportunity there for the ESG agenda. Let's park that there. The second public interest effect is the effect that the merger has on employment. And I'll talk about that a little bit more. The ability, and this is where it comes to participation, equitable participation in the economy, the ability of small and medium enterprises, or for the South African situation, firms owned by historically disadvantaged persons to enter into markets or to expand within markets. In other words, does this merger bring additional obstacles for small and medium enterprises or firms owned by historically disadvantaged persons, would make it more difficult for them to participate in the markets? Then there's the international competitiveness angle. So looking at the ability of national industries to compete in international markets. And then we've got a new public interest factor, which is very different from the others, because the others were other factors as should not have a negative effect on employment on an industrial sector or region. This one says, the last one, which came in through the 2019 amendment, brings in the promotion of a greater spread of ownership by historically disadvantaged persons and, interestingly, workers. So greater participation by and ownership in the economy.
Sure. So South Africa always ahead of its time from a legislative perspective, at least. I think we can say the same for King and our governance provisions. So then if we look at these public interest criteria that you've just laid out and we unpack them in more detail, can you, from your experience, just do that for us, unpack them, and then also talk to us about how they are considered by the competition authorities?
Okay, so I'm going to I'll focus mainly on employment, small and medium enterprises, and the promotion of a greater spread of ownership, because those are the ones that we see most often. This, the effect on a particular industrial sector or region doesn't feature very often in merger control and in the assessment, and also not the ability of international or national industries to become competitive. It's not something that we see often. Employment, we see that all the time. You will, every merger either has an undertaking that there will be no job losses as a result of the merger, or it is imposed as a condition that for a specific period of time there will be no job losses in the merged entity. So we see that very, very often. That employment features key. It's standard. You know that if you have a merger that will have job losses, you will have to show that those job losses would arise irrespective of the merger. Or if it is required for the merger, it would have to be to ensure the sustainability of the firm going forward. So in other words, without the job losses, everybody would lose their jobs because you will have a failing firm. So that's what you basically have around employment. I must just say, when we started this in South Africa, I mean, the idea, and particularly the American lawyers calling and asking for advice on mergers, and at that stage, job losses in the pure capitalist setting was, oh, that's great, that means efficiencies, it means that we have fewer costs. So it was basically a motivation for mergers. We can cull so many jobs, we can reduce inefficiency by removing X number of jobs from the out of the system, and having that conversation with American lawyers to say, well, no, you cannot. For your South African leg of your transaction, you're going to have to make another plan. It's not. It was. I remember actually starting at ENS. And one of the first conversations with an American, he called back 3 times. So, are you sure that we can't?
Just to check you had your facts straight.
Just to check, because it was so foreign, it was so this does not compute, because in their world, it motivates, accept this merger, shareholders, because we are going to save these, save the costs associated with these jobs. So it's very well established that job losses are a no-go in terms of mergers. So, and as regards the other public interest grounds, what we see currently featuring a very high on the agenda is this greater spread of ownership. And when the amendment came through in 2019, it was basically interpreted by everybody, including the competition authorities, about just do no harm, don't dilute ownership. And then what we had in 2021, just need to get my facts straight, yes, in 2021, we had the Burger King prohibition, where Burger King was basically, the investor in Burger King, Brimstone, was basically divesting to a private equity firm its shareholding in Burger King in South Africa, an American private equity firm that had no business in South Africa. So there was absolutely no effect on competition. And the Commission indicated to the merging parties that you've got a dilution of ownership by historically disadvantaged persons from, I think, 60-something% to 0. This has a negative effect on the greater spread of ownership by HDPs. So we are going to prohibit your merger. And what happened in terms of interaction between the Commission and the merging parties at that stage, we don't know, but the next moment they had their prohibition, to the great shock of the industry, because that was the first merger that was ever prohibited purely on public interest grounds. Because what had usually happened, if there is a negative impact on the public interest, it gets cured with conditions. But this was seen as incurable by conditions, or we're not quite sure what happened, but E&S came in and saved the day, was appointed by the merging parties to attend to the reconsideration before the tribunal, and managed to get then an approval of the transaction, subject to a whole basket of public interest commitments, including not just that there won't be any retrenchments, but that the head count would improve at the target entity, but basically in line with the expansion plans that the businesses had, that there would be new shops opened up, new and additional employees, additional investments, etc., etc. So the ownership was diluted, but the other public interest factors on a balance was seen to then outweigh the negative effect in that instance. Now we see that the Commission investigates each and every transaction for a positive contribution to a greater spread of ownership. It raises a whole lot of issues with international mergers, but I don't think we need to go into that in further detail.
It's fascinating. So there's actually now a move towards imposing positive condition or an undertaking, I guess, by the merging parties to do something in the public interest, as opposed to just not doing any harm.
Absolutely. And Jess, I can see how that could potentially translate into the sustainability agenda, to support that.
Absolutely. And do you think that if a merging party were to give positive undertakings relating to, for example, including, more diversity on the board, or other sort of positive undertakings relating to what that merging entity will do in the public interest, do you think that would push the balance towards ensuring that an anti-competitive merger could be approved?
Well, there's nothing in the Act that prohibits that. It is essentially, if those positive contributions outweigh the anti-competitive effects, then theoretically you should have that. It's just that you're not necessarily comparing apples with apples when you are weighing this up, the competition side up with the public interest side, because the competition side, I think it would depend on what industry the merger is. If we're talking about something like basic foodstuffs and markets that would affect the poor specifically, and in other words, you're going to say to the poor, carry this burden of higher prices, but it's going to be great for carbon emission, something like that. I think that would be a difficult sell to the competition authorities. But in other markets where, as we call it, the silk scarves and perfumes market, maybe they wouldn't be that concerned about anti-competitive effects, and it would put a heavier weighting on what the public interest or potentially the sustainability agenda contributions are.
Thank you. I mean, it's interesting to think that the authorities have the ability to weigh that up and to make that assessment. I think it gives a lot of scope for development in that space. So let's move now to thinking about risks for firms or compliance risks for firms. So firms who are looking at their own ESG objectives, looking at ways to change their business, make it more sustainable, ensure that they're taking the E, the S, and the G factors into account, or pursuing at least objectives aligned with those factors. What are the compliance risks that they may face from a competition law perspective?
Okay, thanks, Jess. Well, firstly, I think I must say that where we are looking at unilateral conduct, in other words, a firm taking a unilateral decision to change its behavior to pursue ESG objectives, I think I struggle to see where that could give rise to anti-competitive outcomes. If you give me a long enough time, I can probably think of something, but it doesn't jump up at me. Where I see potentially a risk is where industries get together. So competitors, so you have this coordinated conduct. Competitors say, this is how we are going to behave in an industry. Now, I must just say outright, it's not to say that each and every coordinated effect by industries will lead to anti-competitive outcomes or, give rise to compliance risks. I think it is where you have situations that affect pricing or trading terms, where there's a direct or indirect agreement between parties in a horizontal relationship that sets pricing or trading terms or allocates markets, for example, that could potentially give rise to compliance concerns. I think just to unpack it with an example, where a firm decides that it wants to pursue an ESG objective and it's an environmental objective, and it is not going to use single-use plastic anymore in its business. It takes that decision. It affects its competitiveness because now it has to use more expensive packaging or more expensive inputs in its manufacturing processes. It can be at a competitive disadvantage. Now that can be overcome by just selling your product as an environmentally friendly product, and hopefully consumers will be willing to pay that extra for it. And that's the end of the story. However, if that firm then says, oof, you know what, I don't want to be the first one or the only one that carries this additional burden, I'm actually going to go to my competitors and say that we should all agree that we are not going to use single-use plastics in our business. That, as an industry standard, could be defensible, but where it comes to, you know what, because we are all now facing this increased cost, we are all going to increase our output prices by X amount, that's where the difficulty could come in. It's also, you know, I think what is very important there is because it's an agreement between competitors, and that agreement must affect either the price or the trading terms by which those competitors then interact with their customers. In other words, their customers can't go shop around because they are faced with the same difficulties wherever they go, because there's this industry agreement on that basis.
Okay, because I mean, we know that collaboration is quite important among industry participants in order to get to scalability and standardization, from at least from a sustainability agenda perspective. Yeah. And the point that you're making then is that the important thing to watch, for firms to watch in entering into any kind of standardization or industry collaborative efforts, is around the trading terms and the pricing, and whether a consumer would be prejudiced by that collaboration. Is that correct?
Yes, although in terms of an actual contravention of the Competition Act, if you look at Section 4, which is the cartel provisions, the commission or the complainant doesn't need to show that there is actual consumer harm. All that they need to show is that there's an agreement between parties in a horizontal relationship, and that agreement pertains to price fixing, or the fixing of trading terms, or market allocation. I haven't spoken about market allocation, but another agreement that one could have between and industries to say, well, actually, supplier X is terrible in terms of its environmental impact. We as responsible industry participants are not going to deal with it. So we are not going to buy from that. That would be problematic, to say we agree that we will not buy. The way around that is to say, we have a list, these people are not on the list, they are not compliant with our industry standards, and every party is then free to engage whether they want to or not. Group boycotts can be problematic. Now, I would want to say that, the competition authorities would have a soft ear where it comes to, but we are doing this for ESG purposes. The collaborations are for ESG purposes. But unfortunately, what we've seen in South Africa is that there is a very mechanistic approach to cartel behavior. So I think it's something that parties, industries must just be aware of, where the traps are, and how to not structure out of it, because it will be substance over form, but what to take into consideration and where to draw the line, because it doesn't need to be an outright ban, but one can get the message across without there being a ban, and parties can still make their own decisions. So standard setting, for example, is not a problem, except if those standards are used to exclude others from the market. But I don't think that is necessarily what we have here, will have here.
But I can appreciate that it's a sensitive analysis, one where firms need to act carefully. I mean, certainly what we've seen, and many people would have seen, is the increase in ESG questions in the due diligence, for example, when looking at a supplier and when procuring goods and services from a particular supplier. And that's an international trend that will continue growing. So it will be interesting to analyze whether those types of screening questions and due diligence questions could be seen to be excluding a particular supplier from the market, or whether phrased in the correct way and, as you say, cast in the correct way, not structured, but cast in the correct way, whether they could in fact be acceptable.
Yeah, no, absolutely. I think what is helpful in the unilateral conduct sphere, Jess, is that, it's still a weighing up. Yes, I'm excluding X from participating in the market because I won't engage with them. But the positive side of that is I'm doing it not because I don't want them to compete with me in the downstream market or whatever the case is. I don't want them to, I don't want the negative flow through of their bad behavior, to put it that way, to flow through to my business. And that it's helpful where we have the ability to balance. The difficulty comes in with the cartel provisions where you don't have the ability to defend against. It's, it's a tick box exercise. Are you parties in a horizontal relationship? Does this agreement relate to price? Do not collect 200 Rand, go directly to jail type of thing.
So then if there were firms who were conducting or committing anti-competitive conduct, I understand that there is the possibility to seek an exemption and for one to be granted if that anti-competitive conduct is in the public interest. Can you talk to us a little bit about that?
Sure. So we have that parties to anti-competitive agreements or practices can apply to be exempt from the application of Chapter 2. Chapter 2 is the chapter that regulates behavior of firms, so cartels and abuses of dominance, etc. You can get an exemption for those agreements or practices if those agreements or practices are necessary to achieve a certain objective. And you're going to recognize these objectives when I run through them. The maintenance and promotion of exports. So that's, again, international competitiveness. So it's very similar to the public interest assessments that we had. The promotion of the entry and expansion into the market by small and medium enterprises and firms owned by historically disadvantaged persons. And this we see actually quite often that small and medium enterprises and firms owned by historically disadvantaged individuals trying to enter markets and compete with well-established firms, what this allows for, this exemption allows for us to say, well, okay, you can collaborate, you know, you can set prices together, you can negotiate collectively where other firms may not be able to negotiate collectively if you've come and asked for this exemption, and that exemption is necessary for you to continue competing. Then the third ground for it, obtaining an exemption is a very interesting one. That's the change in the productive capacity necessary to stop decline in an industry. Now, this could be, you know, it doesn't come up often, but this could be, well, actually, we need to, as an industry, get together to invest or to make contributions to prevent this decline in an industry. Individually, none of us are going to do it because, you know, it would be unfair. You're going to have the free rider effect, but we have to collaborate on this. So not something that we see very often. The fourth one is where I think it links very much with sustainability, is the you know, the objective being the economic development, growth, transformation, or stability of any industry. But importantly, it's not just let's get together and go and apply for an exemption. You have to be designated by the Minister of Trade, Industry and Competition first to say, well, actually, we need to be designated as an industry so that we can collaborate on these things, so that we can transform or give rise to stability or have developmental goals that can only be achieved through this collaboration. And then the last one is just competitiveness or efficiency gains that promote employment or industrial expansion. That one is also a 2019 amendment. So it's a new one, and it's a very welcome change because previously you couldn't, on efficiency grounds, actually go and ask for an exemption. So yeah, like I mentioned, I think that it's easy to see how an industry that wishes to transform, an industry that says, listen, we are not sustainable in the long run if we continue with this behavior. We have to collaborate, but we'll all have to do it. Otherwise, you're going to sit with free rider problems or whatever. And we have to approach the ministry for designation and then continue. It's unfortunately quite a long process, as you can imagine, because you need to run through the political process and then the exemption application at the commission itself. It's not quick.
But there is a process at least that could be followed in those instances.
Yeah.
And then when the competition authorities look at these exemption applications, or even actually a merger application that you were talking about earlier, do they consider environmental, social, and governance factors at all in making their decision? I mean, you've spoken about employment, but can you just talk a little bit about that, please?
Yeah, just not packaged in that box, not yet, not what I have seen yet. But I don't think it's something that we are not going to see in future. I mean, we've got the employment side, we've got undertakings to continue investing. You know, there are, I think it's quite possible that those undertakings can then also grow into, well, we are going to invest in greener technologies, etc. I don't think that there's anything that prevents the Commission from looking at that through you know, with a positive lens. But we have seen very little of it to date.
And I think
maybe just sorry to interrupt.
No, I was just going to
mention that what we see at the tribunal when we have hearings, you know, everybody, it's an open hearing, it's a public hearing into a merger. And you know, in the recent matter with Heineken and Distel, something got raised that has, you know, certainly not in the public interest submissions or factors that should be considered, and that was the working conditions of particularly women in the industry. And the tribunal, instead of saying, no, that's got nothing to do with us, actually allowed people to make submissions and to be heard on those. And it's although it wasn't merger specific or anything specific, particularly done with the merging parties, they allowed that to be heard and the issue to be ventilated in an open forum.
And that's an interesting development, because I think that's a move towards considering factors that we would consider social factors, as opposed to purely financial factors when you're looking at whether the merger is an acceptable or not acceptable merger.
Yeah.
And the point I was just interrupting you to make earlier, and sorry for interrupting you, was to just, I guess, raise the point you've made previously, is around the fact that there is an interest in ensuring representation on a board for workers. Which I think is another example of social factors being taken into account when looking at a merger.
Yes, absolutely. And I mentioned earlier that this effect on a particular industrial sector or region, that it doesn't come up that often. But what we have seen, and this is years ago with Tiger and Ashton Canning, and it was an amalgamation of the canning operations of two different canners that would have an impact. And it was also, there were going to be job losses, and those job losses were necessary to ensure the sustainability of the businesses going forward. But what the merging parties offered was training, a training fund, for example, so that there could be those affected employees could then reskill and retrain. And that's another condition that we see quite often, is reskilling and retraining of affected employees in instances where there has been a motivation for job losses.
And obviously reskilling and retraining is a very topical issue in our own energy transition at the moment, and trying to ensure that that is a just transition for the job losses that we know will be associated with closing down power generation based on fossil fuel. Lizelle, let's look now at where because we're seeing, obviously internationally at least, perhaps more so than in South Africa, although we're certainly experiencing this in South Africa as well, a move towards, or a race towards, net zero, and in so doing, and in the fight against climate change and trying to decarbonize operations, seeing the creation of new markets. And as these new markets emerge, they obviously have competition implications. There are competition implications to new markets coming up against old markets. Do you think that our authorities, our competition law authorities, are prepared to ensure that these new markets develop fairly and inclusively?
It's a very interesting question, Jess, and I don't think our competition authorities have grappled with this enough, and certainly haven't. If they have, it's been in their inner sanctum, and it hasn't been done publicly, or they haven't put anything out there yet. As regards development of new markets, generally, competition authorities support that, no matter what cause, because that is progress, and it is an opportunity also for new players to come along and hopefully enter markets before you have incumbents there that have raised barriers to entry and make it difficult for others to continue to participate, or to enter into or to participate in those markets. So I think what we will generally see is that it would be welcomed, and that if there were, for example, complaints laid against entrance into new markets, that they would look at this with a very sympathetic eye towards the longer term sustainability of those markets, and making those markets as inclusive as possible for any new entrants. I must just say, when it comes to competitor collaboration, though, when competitors go to the competition authorities and say, listen, we need to collaborate for purposes of E or S or G, whatever the case may be, I do think that the starting point of the competition authorities are going to be very suspicious, and they will look very carefully whether those objectives can be achieved without the collaboration that the industry wants to undertake. But I do believe that if there is a good case made for collaboration and it is shown that it is necessary and required, that I do think that they will look favorably upon it. But you're going to have to put on your best face to get it through.
So we've spoken now about collaboration within an industry and how that could be helpful in trying to drive innovation or scalability or any of the things that we know we need in order to drive any element of the sustainability agenda, whether it be biodiversity preservation or climate change. But let's now look at it from a policy intervention perspective. So how would our competition law deal with policy intervention in the form of subsidies or the like to encourage new markets to compete with old markets? And I'm thinking particularly of electric vehicles versus internal combustion engines and the move in some jurisdictions to either ban ICE vehicles from a certain future date or to subsidize electric vehicles. How is this accommodated so that competition law doesn't become a barrier to this progress, which we need to see?
So I think what the competition authorities will do is they will deal with it in the ordinary course, the way that they, for example, take into consideration that there are import duties on certain products. Now, import duties can be seen as being anti-competitive because it makes your, it's the reverse of a subsidy, but it makes your local products cheaper, artificially cheaper than your imported products. The competition authorities don't intervene in that. They will just take it into consideration and say, well, this is what it is, and this is how we do our assessment, taking that into consideration. And I think that they'll do the same with that. They won't, to put it that way, they won't interfere with the policy objectives of government, taking that into consideration. The EU has a different approach because they've got a very separate set of rules around state aid and how that gets assessed, because it can distort competition and particularly because they've got the common market objective. So they're a bit different to us from that. So I think that they will generally be supportive of that. I think they will potentially give their inputs when the policy is discussed at government level, but the moment it is ordained, so to speak, I think they will toe the line and won't be obstructive to the agenda.
So not something that can be complained of once the policy has been set.
No, Jess, nobody's stopped from complaining. The road to complain is always open, but how they will deal with it, I think they will take into consideration. Listen, you've got to get with a program. You can't be protected from new markets developing.
No, that makes sense.
Yeah.
Lizelle, I know we're running out of time, but there were some more questions. So what I wanted to ask you then was, if we look at it from a consumer, perhaps welfare perspective, so a consumer protection perspective, in the UK, for example, we've seen the competition authorities there actually investigating claims that have been made, green claims about the greenness or the sustainability of an industry in that economy, and they've tried to regulate that and give some guidance as to when a green claim can be made and not made. Do you think we'll see our South African competition law authorities seeking to protect our consumers against this type of greenwashing or claims that a particular business or firm is greener or more sustainable than it is? Is that something our authorities would seek to do?
Jess, I think not. I think it would certainly, be something that they would point towards in their assessment, but I think that is more a consumer aspect, and where you have the CMA in the UK that does both competition and consumer assessments. In South Africa, we've got different authorities that deal with it. There's been talk about collapsing the Consumer Commission and the Competition Commission, but it hasn't happened. And I think that is something that would fall under the Consumer Protection Act rather than the Competition Act. That's my sense.
No, that makes sense. Thank you, Lizelle. And then I know we have spoken quite a bit about industry collaboration and how important that is to, for example, drive something like decarbonization or achieving a particular SDG. And you have spoken a bit around anti-competitive behavior and when that might be permitted in the public interest. Can you give us perhaps instances or examples in South Africa where our competition authorities have permitted anti-competitive behavior in the public interest, and whether we can take that and apply that towards sustainability if we look forward, and as you said at the beginning, academically at least, as to where this may go?
There have been quite a few exemptions, and there's a ongoing petroleum exemption, that keeps on being renewed every 3 or 4 months. For the petroleum industry in terms of collaboration to ensure certain, security of supply, etc. So, and other exemptions that we've seen for anti-competitive conduct is in the hospital industry, that we've seen that small and medium enterprises and firms owned by historically disadvantaged individuals are allowed to collaborate on price negotiations with medical schemes for their individual hospitals in the long run. So there are a couple of examples like that. I think also quite interesting, there's a recent, it's only a draft guideline or a draft at this stage, but a guideline for the agricultural industry, for small and medium enterprises and firms owned by historically disadvantaged persons, that they may engage in certain anti-competitive practices. It's a block exemption. It's the first of its kind that we're seeing here in South Africa, block exemption against certain anti-competitive conduct to ensure that it's easier for them to participate in the market, and that they don't have the same obstacles as larger firms. So not a direct example of sustainability views, but I do think that it's, the door isn't closed for that. I must just say, I mean, we're talking a lot about anti-competitive collaboration and the like, but I must just say again, and I think you've mentioned it as well, is that not all collaboration between competitors in pursuing sustainability goals would be seen as anti-competitive. So don't want to frighten people away and say, oh goodness, we can't have this conversation anymore. It's an important conversation. It needs to continue. And there are just a couple of things to look out for. It's a couple of danger points, but for example, standard setting, yes, it can be anti-competitive, but if it's intended to exclude others from the market or to raise barriers to entry into the market. But if it has as it's if it's objectively justifiable, and in other words, in the long run, pro-competitive and pro-development and pro-sustainability, there's a lot, it's very likely that it wouldn't fall foul of the provisions of the Competition Act, the relevant ones. It's just those horizontal agreements that industries have to look out for in the way that they engage with those.
And I think that's actually an excellent point to just underline and perhaps end on, is that standard setting and codes of conduct and industry competitors within an industry coming together to try and find a standard way or a standard, I think about the sustainable finance space, looking at trying to find standard wording or legal wording or riders to be used in deploying sustainable finance. So just to underscore again the point you're making, that kind of collaboration is not necessarily anti-competitive and is permissible in the sense that it doesn't go to pricing or to trading terms, if I sum that up correctly.
Yeah, and the way I understand it as well, Jess, is that the ultimate agreement is between the funder and the lender, and those two parties will agree to the terms. The standard wording is to actually bring barriers down, to make it easier. So our competition authority, like I say, sometimes takes a tick box approach to these things, but I think, you know, what you've explained to me is that that's perfectly permissible.
Thank you, Lizelle. So to end off, I'm going to ask you to look into your crystal ball and tell me if you think in the future we'll see a special carve out or some other type of legislative development, perhaps something like the block exemption you're talking about in the agricultural space. If you think we'll see something like that to actually allow anti-competitive conduct, which is in the interest of one of the environmental objectives particularly, so something like decarbonization to tackle climate change, something to tackle biodiversity loss or water resource preservation. Do you think we'll see that in the future?
There's nothing on the cards at the moment, Jess, but I certainly hope so. And I think that it's probably for us and for this group to lobby for something like that. I mean, the amendments to the Competition Act didn't come from nowhere. So it might be something that one needs to say, listen, you know, given where we are, that under the public interest assessment, we also need to bring in both in terms of mergers and behavioral practices, and then both of them three. But, you know, also in terms of exemptions, we need to bring in a sustainability ground as well.
Yes, thank you. Well, thank you for that call to action, Lizelle, to end on. And thank you very much for...
lost Jess.
I'm still here. Can everybody hear me?
Okay. Yes, there you're back.
Okay, fantastic. Technical glitch right at the end. I was just saying thank you for that call to action. And thank you for what's been a fascinating discussion, trying to unpack and look at the intersection between competition law and also ESG and sustainability. So thank you, Lizelle, for your time and for joining us today. And thank you to all the attendees for being with us and for being part of this discussion. Just to remind you again, there are still 8 masterclasses left in our series. And if you still need continuous professional development hours, you can join us for those. You can register at the link that most of you have. Otherwise, you can email our events team to be registered for those events. And then just again, to reiterate the invitation I extended at the beginning, please do join us in Cape Town or in Johannesburg for our networking opportunities. And really, it's just an opportunity for you to meet the various practitioners that have been part of this masterclass series, and perhaps to ask that burning question that you just didn't add into the Q&A block. Thank you very much, everybody, and we will see you again at the next masterclass session. Thanks, Lizelle. Thank you.
Thanks, Jess. Thanks, everybody. Goodbye.